arbitration, we thought why not connect with the topic on which there's a lot of debate, like can two Indian parties agree to a foreign seated arbitration? As we all see that at least Mr. Ajay Thomas can make me stand corrected. At least I didn't find any judgment direct of the Supreme Court, though there have been judgments regarding the Madhya Pradesh from Sasan Power, then relying upon the Atlas exports and the Reliance Industries, and wherein there was some Supreme Court's reference in this regard in the judgment as to how the validity of the arbitration in respect of two Indian parties can choose regarding the foreign seated arbitration sector. But without taking much time, since I know they are all working days, I would request Mr. Thomas to take things forward. And we are happy that he has acceded to our request to share his knowledge. Over to you, Ajay.
Thank you, Vikas. And thank you, CLC, for your kind invitation again to me to actually speak to you on what I believe is one of my very favorite topics in recent times. It's been a favorite topic because the law has been evolving with various decisions emanating from the various high courts. Although we will see today whether there is any definitive Supreme Court decision on the same matter. So that is going to be the focus of my presentation. So can I confirm that my slides are visible? Excellent. So ladies and gentlemen, good morning, good afternoon, and good evening, depending on which part of the world you are in. I see that we've got some friends of ours who've joined in all the way from England and London, more particularly. So welcome to this webinar, which is going to be a brief insight or overview of my thoughts on this vexed question as to whether two Indian parties can choose a foreign seat of arbitration or not. And that is going to be the focus of my presentation and speech for the next 35 minutes. So ladies and gentlemen, when you're looking at the issue of whether two Indian parties can choose a foreign seat of arbitration or not, it is very important for us to understand the implications of the choice of a seat of arbitration. Why is it so important to choose a seat of arbitration? Why is it that Indian parties might want to have a seat of arbitration outside of India? Are there any cogent, pressing reasons why they might want to do that? And that is also going to be a focus of what I'm going to be speaking on today. So when we're looking at seat of arbitration, ladies and gentlemen, we must remember, as I said in the last lecture, that arbitration doesn't function in a vacuum. Arbitration doesn't operate in a legal vacuum. The process of arbitration requires the public justice system represented by the courts of the land to give validity and sanctity to the process of arbitration. Without the courts and the support of the courts of the land, it will be very difficult for the process of arbitration to be there as a freestanding system of justice. And that is why, ladies and gentlemen, every arbitration is rooted in a particular legal jurisdiction. Every arbitration has a juridical seat. And the juridical seat of arbitration, ladies and gentlemen, is the primary legal jurisdiction to which an arbitration is anchored. And why is this important? Anchoring of the arbitration to a particular seat or a jurisdiction is important because it gives it legitimacy, it gives the arbitration legality, and also it gives it nationality. And this, again, is something which has been beautifully summed up by the Supreme Court in a 5-judge constitution bench in that landmark case called Bharat Aluminium versus Kaisar Aluminium, where the Supreme Court said that, and I quote the Supreme Court, "It is accepted by most experts that in most of the national laws, arbitrations are anchored to the seat, place, situs of arbitration." And the Supreme Court goes on to quote Redfern and Hunter, one of the most authoritative books on international commercial arbitration, to conclude that the seat of arbitration is intended to be the center of gravity of an arbitration. So, ladies and gentlemen, it is very important, therefore, to choose a seat of arbitration because of three reasons. Seat fixes which law would govern the conduct of the arbitration. It decides which courts can have supervisory and supportive jurisdiction over the arbitration. And it also determines the nationality of an award, which is so important from the purposes of enforcement of an award under the New York Convention. And law of the seat of arbitration, ladies and gentlemen, automatically flows from the choice of a seat of arbitration. The lex arbitri, the technical term for the law of the arbitration seat, automatically flows when you make a choice of a particular jurisdiction as a seat of arbitration. It is not a matter of choice. So let me start off, ladies and gentlemen, by sharing with you the results of a study conducted by Queen Mary University of London and its School of Arbitration, which was done in association with the international law firm White and Case. So this study conducted in 2018, ladies and gentlemen, was titled The Evolution of International Arbitration. And I'm going to share with you just two aspects of the study and the report which this study culminated in. So what you see on your screen, ladies and gentlemen, is a report or the results of a particular question which was asked of the respondents in this survey as to which was the most preferred seat of arbitration of the respondents' organizations. And if you see the results, ladies and gentlemen, London still appears to have the edge, followed by Paris, Singapore, Hong Kong, Geneva, New York, and Stockholm. Now, this is important, ladies and gentlemen, because this slide gives you an insight into what are the most popular seats of arbitration internationally. So if you want to look at it from an Indian perspective, from the perspective of an Indian organization, my sense is that it would be Singapore, London, Paris, Hong Kong. That would be the order in terms of the most preferred seats. But of course, the Queen Mary study is an international study, and therefore the results are very different from what it would have been had the respondents been predominantly an Indian base of respondents. Again, very interestingly, ladies and gentlemen, what was asked of the respondents was this question as to what were the four most important reasons as to why you would select a particular seat of arbitration. And the results here also make for very interesting reading. If you see the results, it says the number one reason why people chose a particular seat was the general reputation and recognition of that seat. The second most important reason was neutrality and impartiality of the local legal system. Thirdly, national arbitration law. And fourthly, track record in enforcing agreements to arbitrate and arbitral awards. And fifthly, which is not too down the list in terms of ranking, is the availability and quality arbitrators who are familiar with the seat. So, ladies and gentlemen, these are the five most important reasons why parties would choose a particular jurisdiction to be the seat of arbitration. And if you see, these are also probably the reasons why in recent times there has been this trend for Indian parties to have a seat of arbitration outside of India. So you might ask me, what is the controversy out here? two Indian parties are already having a seat of arbitration outside of India. So what is the issue out here? My response to that would be that if the award is not challenged and is voluntarily enforced, there is no problem. But if that award might have to be enforced in India, then there is a big possibility that it might not be enforced because there is there's a very high likelihood that a court might not uphold that award on the grounds that it interferes with the public policy of India. So that, ladies and gentlemen, is something that we need to keep in mind. So why do Indian parties, why is it that we have this recent trend, I would say, of Indian parties wanting to have a foreign seat of arbitration? And this is what I'm trying to be explaining with this slide of mine. I would say that firstly, there is a perception. There's a perception that courts in India tend to interfere in the process of arbitration much more than they would do in other jurisdictions. So I said I'm emphasizing the word perception. It may not be the reality. There is a perception amongst Indian parties that courts in India tend to interfere much more in domestic arbitrations seated in India vis-a-vis international commercial arbitration seated in India and foreign seated arbitrations. So this perception, ladies and gentlemen, has been reinforced, I would say, in recent times because of the insertion of subsection 2A in section 34 by the 2015 amendments to the Indian Arbitration and Conciliation Act. So if you see section 34 2A, which has been now inserted, it says that an arbitral award arising out of arbitrations other than international commercial arbitrations may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award. So, ladies and gentlemen, so this perception of greater interference by the courts in domestic arbitrations, that is, arbitrations involving two Indian parties, vis-a-vis an international commercial arbitration seated in India and foreign seated arbitrations, is not wholly unjustified, because now, under the 2015 amendments, this ground of patent illegality, this additional ground of patent illegality to set aside an award, it will be there only in domestic arbitrations. It would not be there when your arbitration is seated outside of India. And this, ladies and gentlemen, to evade or to escape this ground of patent illegality and the setting aside of an award on this ground is one of the predominant reasons why you have parties today and lawyers advising parties to Indian parties to have a seat of arbitration outside of India. And secondly, ladies and gentlemen, there is another perception that arbitration seated outside of India, there is greater speed and efficiency in the delivery of these of awards in these foreign jurisdictions. Again, my view, ladies and gentlemen, is that I don't think this perception is entirely true. Post 2015 amendments to the Indian Arbitration and Conciliation Act, I believe there has been a great deal of discipline which has been injected into the arbitration process in India by virtue of a deadline for completion of arbitrations. So this perception that arbitrations seated outside of India are speedier and more efficient, I think is not justified given the manner in which arbitrations are conducted today post 2015. And that essentially, ladies and gentlemen, is because there is now a deadline of 12 months from the completion of pleadings for an award to be delivered. Very rare would it be for you to find such a timeline or a deadline incorporated in the statute for completion of an arbitration. Let's take the example of, say, the UK or the arbitration statute in Singapore. There are no deadlines, specifically incorporated into statute with respect to how quickly you should complete an arbitration. But we have that in India, and that was to a large extent because of the great lack of discipline which was there in the process of arbitration in India. And it was those circumstances which forced the government to take a drastic step of having a timeline incorporated into the arbitration statute itself. So, ladies and gentlemen, this is why I believe, these are my views as to why you find that there has been this trend in recent times for two Indian parties to have a seat of arbitration outside of India. And of course, there have been decisions, there have been certain decisions, I would say no definitive decisions, but there have been certain decisions by virtue of which lawyers tend to be using, in favor of making a case that the law has evolved to the stage that two Indian parties can actually have a seat of arbitration outside of India. And to what extent has the law evolved? What is the jurisprudence relating to this area of arbitration proceedings? That is going to be the focus of my short, brief presentation today. So, ladies and gentlemen, when you're looking at this issue of whether two Indian parties can have a seat of arbitration outside of India, you will find that there is an interplay between two basic principles which relate to the process of arbitration. One is the fundamental basic grund norm, if I may call it, of the doctrine of party autonomy, and second would be the doctrine of public policy. So you would find the interplay, this question as to whether two Indian parties can have a seat of arbitration outside of India. In deciding this issue, you will find a sort of conflict between these two basic principles affecting arbitration. So what exactly is party autonomy? All of you know that party autonomy is the ability of parties in an arbitration to decide the procedure of arbitration. To decide, arbitration provides parties the flexibility to decide the process of an arbitration. It gives you the flexibility to decide who is going to decide your dispute. It gives you a great deal of flexibility with respect to procedural matters in an arbitration. And that all stems from this fundamental principle of party autonomy. And this party autonomy, ladies and gentlemen, with respect to the choice of a seat of arbitration, which is also called place of arbitration, is there in Section 20 of the Indian Arbitration and Conciliation Act. Section 20 says that parties are free to agree on the place of arbitration. So party autonomy effectively is giving parties the freedom to choose the place of arbitration. But Section 20, ladies and gentlemen, has to be read with Section 2, subsection 2 of the Indian Arbitration and Conciliation Act, which says that this part shall apply only where the place of arbitration is in India. So where the place of arbitration is in India, Section 20 applies, and it gives parties the full freedom to choose and agree on a place of arbitration. And this, to a large extent, is derived from Article 20 of the UNCITRAL Model Law, which is the basis on which the 1996 Arbitration Act in India was based on. And Article 20, if you see the language, is the language of Section 20 of the Indian Arbitration and Conciliation Act is borrowed entirely from Article 20 of the UNCITRAL model law. And if you want to go to the English Arbitration Act of 1996 and Section 3 of the English Act, again you will find that the same freedom and flexibility is also given when your seat of arbitration is in England. And when the English Arbitration Act applies, Section 3 says that in this part, the seat of arbitration means the juridical seat of arbitration designated by the parties to the agreement. And if you were to go to Singapore and look at the Domestic Arbitration Act, which is the AA or the Arbitration Act, Section 2.1 defines the place of arbitration as the place of arbitration means the juridical seat of arbitration designated by the parties to the arbitration agreement. So, ladies and gentlemen, the short point I'm trying to make by doing a comparative or looking into comparative provisions relating to this party autonomy vis-a-vis choice of arbitration seat is to tell you that the language in the Indian Arbitration Act is pretty similar to what is there in the statutes, which is given the statutes of Singapore and the arbitration statute in England and Wales, and also in the UNCITRAL model law. So this background, I believe, is very important when people say that the Indian statute does not give parties the autonomy to choose a seat of arbitration. So when somebody tells you that, I think you need to look at the provisions of Section 20, subsection 1, where there is freedom and autonomy given to the parties to decide the seat of arbitration. Okay, so now when you're looking at this, ladies and gentlemen, you're looking at party autonomy. You are also looking at the opposite, slightly conflicting doctrine of public policy. Now, public policy, as many of you might be aware, is one of the most common grounds for challenging an award in India. Prior to the 2015 amendments of the Arbitration and Conciliation Act, it was relatively very easy to challenge an award on the grounds of public policy. But now, post 2015 amendments, public policy, the contours of public policy, although it's an unruly horse, have been reined in to a certain extent. And challenging an award has become much more difficult thanks to the automatic stay, removal of the automatic stay on the operation, on the execution of an award, which was there earlier, and which has now been removed under the 2015 amendments of the Arbitration and Conciliation Act. So, ladies and gentlemen, one of the grounds on which it has been argued in a lot of cases in India that two Indian parties cannot have a seat of arbitration outside of India is that it would be a violation of the principles of public policy. Permitting two Indian parties to have a seat of arbitration outside of India would effectively mean that these two Indian parties are contracting out of Indian law, Indian substantive law. And in this connection, quite often, Section 28 is brought into the whole picture. Now, Section 28 actually deals with the substance of a dispute. And if you see, Section 58 starts with the words, where the place of arbitration is situated in India, in an arbitration other than an international commercial arbitration, the arbitral tribunal shall decide the dispute submitted to arbitration in accordance with the substantive law for the time being in force in India. So this, ladies and gentlemen, has been taken as the basis to state that two Indian parties, when the place of arbitration is situated in India, cannot choose a foreign substantive law of the contract. But there have been certain decisions where this has been stretched to also refer to the procedural law of the arbitration. And therefore, there is a line of thinking, if you analyze certain decisions of the High Court and Supreme Court in India, that two Indian parties, by virtue of having a seat of arbitration outside of India, would tend to be derogating from Indian law, which would automatically apply to the situation. And the first decision and the most important decision, which is quite often cited in favor of the argument that two Indian parties cannot have a seat of arbitration outside of India, relates to a series of contracts tendered by the National Highway Authority of India to two organizations, TDM Infrastructure and UE Development. So TDM Infrastructure and UE Development essentially relates to certain subcontracts of work relating to the construction of National Highway Authority of India highways in India. And TDM Infrastructure versus UE Development, which is a 2008 decision of the Supreme Court of India, a decision which was delivered by a single judge of the Supreme Court, Justice S.B. Sinha. So if you were to look at this, if you were to look at the clause in this, in the arbitration agreement out of which this dispute arose, it said that it made a provision, it made a reference to the provisions of the Indian Arbitration Act 1940, and then it went on to say that the venue of the arbitration shall be New Delhi, India, and the language to be used in the arbitration proceedings shall be English. So here was a case, ladies and gentlemen, which came up before the Supreme Court with respect to the appointment of an arbitrator. And it came up, as you all know, when there is an international element, or there is an international commercial, when there is an international commercial arbitration, which has been defined under the Indian Arbitration Act to have to be an arbitration involving a foreign element or a foreign party, then the default appointing authority in those cases is the Supreme Court of India. So it is under that jurisdiction that the parties approach the Supreme Court of India. Now, here is a case where both the parties were incorporated in India. Both the parties were incorporated under the provisions of the Indian Companies Act 1956. But the central management and control of TDM Infrastructure was exercised in Kuala Lumpur, Malaysia. And this, ladies and gentlemen, was essentially due to the fact that the directors and shareholders were residents of Malaysia, and the board of directors also held their meetings in Malaysia. And therefore, ladies and gentlemen, it was said that the central management and control of this company was exercised in Malaysia. And because it was the central management and control was exercised in Malaysia, the arbitration was an international commercial arbitration, and the Supreme Court had the power to appoint an arbitrator in this matter. So the issue before the Supreme Court was whether this agreement between the parties, essentially two Indian parties, two companies incorporated in India, but where one of the parties had the central management and control was exercised in Kuala Lumpur, Malaysia. So the issue was whether this agreement falls within the purview and the definition of Section 21F of the Indian Arbitration and Conciliation Act, which defines the concept of international commercial arbitration. And if you read the decision, ladies and gentlemen, the ratio in this case was that the Supreme Court very clearly held that a company incorporated in India can only have Indian nationality for the purposes of the Act. It cannot be said that a company incorporated in India does not have an Indian nationality. Therefore, where both parties have Indian nationality, then the arbitration between such parties cannot be said to be an international commercial arbitration. So the test of deciding the nationality of a party here was decided as the place of incorporation of the two parties. So this, ladies and gentlemen, was a ratio of the case. Please remember this. The ratio was with respect to the fact that nationality, the place of incorporation of the of parties, is the test to decide whether the arbitration is an international commercial arbitration or not. But from the perspective of public policy and from the perspective of whether two Indian parties can have a seat of arbitration outside of India or not, TDM infrastructure versus UE development is quite often quoted, ladies and gentlemen, and I believe it's often quoted wrongly, because what is quoted is the obiter in this decision. And this obiter in this decision is given in para 20. And para 20 relates to section 28 of the Indian Arbitration and Conciliation Act. And it says that the intention of the legislature appears to be clear that Indian nationals should not be permitted to derogate from Indian law. And this is part of the public policy of the country. So this lines, ladies and gentlemen, the intention of the legislature appears to be clear that Indian nationals should not be permitted to derogate from Indian law. This is a part of the public policy of the country. So para 2 in TDM infrastructure versus UE development is quite often quoted in support of the contention that two Indian parties cannot have a seat of arbitration outside of India. So, ladies and gentlemen, I believe that this quoting of this obiter in TDM infrastructure versus UE development has very shaky precedential value for three reasons. One, the observations which were made with respect to the nationality of the parties and with respect to public policy being violated by Indian parties derogating from Indian law were made in an application under Section 11 of the Arbitration and Conciliation Act, which relates to the appointment of an arbitrator, and which has been argued that such an order of the court is not strictly comes within the definition of a court, and therefore the provisions of Article 141 of the Constitution will not apply. So that's one reason why this is has got shaky precedential value. The second reason, ladies and gentlemen, is that the case, if you see, refers, albeit an obiter, refers only to the prohibition of two Indian parties contracting out of Indian substantive law. Because see that it has been decided in the background of Section 28 of the Indian Arbitration and Conciliation Act, which deals with the substantive law of the contract and not to the lex arbitri or the law of the seat of arbitration. So that's another point that you need to keep in mind. And thirdly, ladies and gentlemen, the Balco decision, the landmark Bharat Aluminium versus Kesar Aluminium decision, clearly, very, very clearly and explicitly stated that Section 28 of the Indian Arbitration and Conciliation Act is restricted only to the substantive law of the contract and has got nothing to do with the choice of a foreign seat or a foreign curial law or a foreign lex arbitri or a foreign law to govern the arbitration agreement. So Balco very clearly says that Section 28, its import is restricted only to substantive law of the contract and not beyond it. So, ladies and gentlemen, that's one decision which I think quite often quoted in support of the fact that two Indian parties cannot have a seat of arbitration outside of India. And that, I believe, has got is a very doubtful, it's a very doubtful precedent. It's got very shaky precedential value. The next case, ladies and gentlemen, refers to what you see on your screen. It's a dispute which arose out of a contract relating to the export of groundnuts. This was the case, a 1999 decision of the Supreme Court of India, Atlas Exports versus Kotak and Co. This is important, ladies and gentlemen, because this is a case which is most often quoted by parties and also by the various courts in support of the proposition that two Indian parties can have a seat of arbitration outside of India. So TDM is quoted very often, wrongly in my view, for the proposition that two Indian parties cannot have a seat of arbitration outside of India. Whereas Atlas Exports, on the other hand, you will find that all those decisions wherein the courts have held that two Indian parties can have a seat of arbitration outside of India have quoted Atlas Exports. So it will be very important for us to understand and see what does this decision deal with. Now, this was a two-judge bench of the Supreme Court of India comprising of Justices S.C. Babu and R.C. Lahoti. This was a tripartite agreement where the seller was an Indian party, the buyer was a organization, a company based in Hong Kong, and there was also a broker involved in the case, Kotak and Co., which was an Indian entity. Although there was a tripartite agreement, the dispute and the resultant arbitration was only between the seller and the broker. And what did the clause say? It's very important for us to look into the clause, ladies and gentlemen. Now, the clause made a reference to the GAFTA rules. It was a GAFTA contract. GAFTA, as most of you would be aware, stands for the Grain and Food Trade Association, which is based out of London. And the arbitration clause made a reference to GAFTA arbitration and section 20 and clause 27 of the standard contract number 15 of GAFTA. The arbitration clause says that all disputes arising out of this contract shall be settled by arbitration in London in accordance with the arbitration rules of the Grain and Food Trade Association Limited. So you have a clause which makes a reference to GAFTA rules and the seat of arbitration in London. So what was held in this case, ladies and gentlemen? So this was a case, it was held. So let's look at what were the contentions before looking into what was held in this case. It would be very important for us to, I think, to look at the contentions of the parties in this case. In this case, it was held that, or rather, it was argued by Atlas, the seller in this case, that the award should be unenforceable because the contract between the two parties was unenforceable because it was opposed to public policy, as mentioned in section 23, read with section 28 of the Indian Contract Act. And under section 23 of the Indian Contract Act, ladies and gentlemen, the consideration or objective of an agreement is unlawful if it is opposed to public policy. And the argument was made before the court that here was a case where you had two Indian parties and the arbitration agreement was compelling two Indian parties to resort to an arbitration by foreign arbitrators in a foreign land, thereby impliedly excluding the remedy which is available to them under the ordinary law of India. And because the remedy available to them under the ordinary law of India is unavailable, therefore, the argument made by Atlas was that this should be held to be opposed to public policy. So this was the argument which was run. And what did the two-judge bench of the Supreme Court hold? Now, this was a decision written by Justice R.C. Lahoti, who, as you know, later went on to become the Chief Justice of India. And Justice Lahoti held that this case in hand is very clearly covered by exception 1 to section 28. Exception 1 to section 28 says that the rules mentioned in section 28 do not apply to arbitrations. So Justice Lahoti held that the right of parties to have recourse to a legal action is not being excluded by this agreement. So merely because the arbitrators are situated in a foreign country, and this is important, the court went on to hold that merely because the arbitrators are situated in a foreign country cannot by itself be enough to nullify the arbitration agreement on public policy grounds when the parties have, with their eyes open, willingly entered into the agreement. So if you see, ladies and gentlemen, Atlas Exports, the issue involved was as to whether two Indian parties, by agreeing to submit their arbitration to foreign arbitrators in a foreign land, is that violative of the public policy of India contained in section 23, read with section 28 of the Indian Arbitration and of the Indian Contract Act. And here was a case, ladies and gentlemen, that the court held that merely because of this reason, it cannot be a violation of public policy, and it cannot be a ground to nullify the arbitration agreement on the public policy grounds. So, ladies and gentlemen, again, I honestly believe that Atlas Exports is, again, like TDM, has got slightly shaky precedential value. And I've got three reasons why it is of slightly shaky precedential value. One, this was a decision under the Arbitration Act of 1940. The Arbitration Act of 1940 was replaced in 1996 by a brand new Arbitration and Conciliation Act of 1996. So, can the ratio of a decision given under the previous statute, which no longer exists, can it be used as a precedent? Does it have solid binding precedential value? That's one reason why I think we are not on such solid ground. The second reason, ladies and gentlemen, is that the Supreme Court in Atlas Exports, while upholding the award, did not clearly answer the question as to whether two Indian parties can choose a foreign seat of arbitration. This issue was not squarely, directly before the bench. And thirdly, ladies and gentlemen, if you read the agreement, there was a foreign element. One of the parties to the arbitration agreement, that is a buyer of the groundnuts, was a party incorporated in Hong Kong. So it was not a case of there being simpliciter just two Indian parties. There was a foreign element where the buyer in the original tripartite agreement, although the buyer was not a party to the arbitration and the dispute, but the buyer was a Hong Kong-based party and was definitely a party to the original agreement. And therefore, ladies and gentlemen, these are three reasons why I believe Atlas Exports is of doubtful precedential value when you're looking at the proposition as to two Indian parties having the ability to have a seat of arbitration outside of India. But Atlas Exports is the most often quoted decision by the high courts in favor of deciding that two Indian parties can actually have a seat of arbitration outside of India. And that is why, ladies and gentlemen, I wanted to deal with these two decisions first. And both, I honestly believe, with the greatest of respect to the Supreme Court, that both these are of slightly shaky precedential value. Because precedential value, because as this caricature on your screen shows, at times I think the courts have erred to see whether what has been mentioned in those decisions is actually the ratio or is it obiter. And with the greatest of respect, I believe many a times what has been quoted in support of the two respective contentions is not the ratio of those respective cases, but it has actually been the obiter in those two decisions. So moving on, ladies and gentlemen, from from groundnuts, I move on to another case which deals with a tanker voyage charter party under a standard form tanker contract of the Association of Shipbrokers and Agents of the United States of America, better known by its short form ASBA Tank-Voy. So this was a case, ladies and gentlemen, Seven Island Shipping versus Shah Petroleum. It's a 2012 single judge decision of the Bombay High Court, delivered by Justice B.R. Gawai, who today is now on the Supreme Court. And the clause, if you read, ladies and gentlemen, in this case, talked about the place of arbitration proceedings to be London/New York. So what happened in this case was a suit was filed before the Bombay High Court by the plaintiff, and the defendant sought a reference under Section 45 to arbitration because there was an arbitration clause. So once there was an arbitration clause, a suit would not lie in the matter. And therefore, there was this application made under Section 45 by the defendant in the suit asking for a reference to arbitration. So the single judge of the Bombay High Court held that the parties had actually not made a choice between the two seats of arbitration, New York and London. And there was nothing to show in the arbitration agreement that the arbitration was to be seated in London in accordance with English laws. Although this was argued by one of the parties that the arbitration clause makes a reference to arbitration in London in accordance with English laws, the court held that there was nothing on the record that the parties had chosen between New York and London. And then the court, again in this case, relying on the Supreme Court single judge decision on TDM Infrastructure, said that since both the plaintiff and the defendants are companies incorporated in India, even for the sake of argument, there is an arbitration agreement. It cannot be an international arbitration agreement and as such not valid in law. And the court, quoting TDM Infrastructure, went on to hold that as per Section 28 and the public policy ground, two Indian parties should not be permitted to derogate from Indian law. So if you see, Seven Islands versus Shah Petroleum, in a way, was saying that two Indian parties cannot derogate out of Indian law. And if they were to derogate from Indian law, it would be a violation of public policy. And therefore, what happened, ladies and gentlemen, in this case is that the court rejected the defendant's prayer under Section 45 for the reference of the dispute to arbitration. So this is another case, ladies and gentlemen, in support of the proposition that two Indian parties cannot have a seat of arbitration outside of India. So you have TDM Infrastructure versus UE Development, single judge of the Supreme Court, and you have Seven Islands versus Shah Petroleum, single judge of the Bombay High Court. Ladies and gentlemen, the next case in this line of cases on this issue relates to the certain blocks, oil and gas blocks, which were auctioned by the government of India to Reliance, relating to the Tapti and Mukta offshore offshore, areas, which are basically just off the, off the coast of western coast of India, in the Gulf of Cambay. So this, ladies and gentlemen, was a case as a two-judge bench of the Supreme Court of India, Justices Nijjar and A.K. Sikri. This was a case where there was an application filed challenging an award delivered in an arbitration between Reliance and Union of India. The challenge application was filed under Section 34 in the Delhi High Court, and this was an appeal filed against the decision of the Delhi High Court, allowing for a Section 34 application to be filed in a case which was essentially relating to a foreign award. Foreign award, ladies and gentlemen, because if you were to read the arbitration clause, the seat of arbitration in this case was London. The law of the arbitration agreement was English law, but the substantive law of the contract in this case was Indian law. So the Supreme Court in this case held that the Section 34 application challenging a decision, a foreign award, would not be maintainable in India because the seat of arbitration in this case was London, and the challenge to the award would have to be filed at the courts of the seat of arbitration, which is London. And therefore, ladies and gentlemen, the court said that the Delhi High Court did not have the jurisdiction to entertain a Section 34 application. Now, this, ladies and gentlemen, is another case which is quoted in support of the proposition that two Indian parties can have a seat of arbitration outside of India. But again, ladies and gentlemen, in my honest view, I believe that this is again a doubtful precedent, because this was not a case where the Supreme Court expressly decided the issue as to whether two Indian parties can choose a foreign seat of arbitration or not. At best, this could be a precedent which recognizes that somehow, obliquely or impliedly, that two Indian parties could choose a foreign seat. This issue was not squarely before the Supreme Court of India. And ladies and gentlemen, again, I believe Reliance Industries versus Union of India is a doubtful precedent because, again, there was a foreign element in this case. This foreign element came in the form of the second appellant, which was BG Exploration Production India Limited, which was a company incorporated under the laws in the Cayman Islands. So again, there was a foreign element. It was not a dispute simpliciter between two Indian parties, Reliance Industries and Union of India. There was a foreign element with BG Exploration, which was a Cayman Islands incorporated entity. So therefore, again, ladies and gentlemen, I believe this cannot be a very strong precedent in favor of the proposition that two Indian parties can have a seat of arbitration outside of India. The next case, ladies and gentlemen, is a 2015 decision of the Bombay High Court, Adar Mercantile versus Sri Jagdamba Agrico Exports. This again is a single judge bench of the Bombay High Court, Justice Dhanuka. And the clause in this contract was very interesting, ladies and gentlemen, almost on the verge of being, a pathological clause. It said arbitration in India or Singapore and English law to apply. This was again an application filed under Section 11(6) for the appointment of an arbitrator. And the single judge of the Bombay High Court held that since both the parties are Indian and the agreement was executed in India, the court relied on the single judge decision of the Supreme Court in TDM Infrastructure and held that two Indian parties cannot derogate from Indian law, and therefore it would not be possible to have a seat of arbitration in Singapore under English law, and the dispute would necessarily have to be resolved through arbitration in India. Again, ladies and gentlemen, it is relying on the doubtful precedent, TDM infrastructure. But again, this is a case which is often quoted for the proposition, in support of the proposition that two Indian parties can have a seat of arbitration outside of India. Again, I think it's not on very solid footing. The next case, ladies and gentlemen, relates to this power project. It's a power project of a subsidiary of Reliance called Sasan Power, which is in the state of Madhya Pradesh. So this, ladies and gentlemen, there are two decisions out here. There is a Madhya Pradesh High Court division bench decision upholding the fact that two Indian parties can actually indeed have a seat of arbitration outside of India. And then you have the matter going in appeal to the Supreme Court, and then we'll see what the Supreme Court decides in this matter. So that, ladies and gentlemen, is, in my view, one of the most beautiful high courts in India. It's the High Court of Madhya Pradesh at Jabalpur. I think it's a very fine specimen of colonial architecture in India. So let's see, ladies and gentlemen, what did the division bench of the High Court comprising Justices Rajendra Menon and Sushil Kumar hold. So this was a case, ladies and gentlemen, as I said, relating to a power project, Sasan Power. Sasan Power entered into a contract with North American Coal Corporation, and then there was an assignment of that contract by North American Coal Corporation to its Indian subsidiary, which was North American Coal Corporation India. So the clause in the contract, ladies and gentlemen, the governing law made a mention of governing law of the laws of United Kingdom. And with respect to the dispute resolution, it said that the dispute should be resolved by arbitration administered by the ICC in Paris, and the place of arbitration would be London, England. So this matter basically came up before a division bench of the Madhya Pradesh High Court against an order passed by a single judge of the Madhya Pradesh High Court upholding the dismissal by the district judge in Singrauli of a civil suit filed by Sasan Power pursuant to an application filed by North American Coal Power Corporation India under Section 45 of the Arbitration Act, read with Order 7, Rule 7 of the Code. So the district court had held that since the parties had entered into an arbitration agreement and the dispute was covered under Part 2 of the Act, the bar under Section 45 was retracted, and therefore the suit was not maintainable. It was argued by Sasan Power that two Indian parties cannot agree for an arbitration in a foreign country according to the law of that country, and that would be violative of Section 23 of the Indian Contract Act and the law laid down by the Supreme Court in TDM Infrastructure. And the two-judge bench of the Madhya Pradesh High Court held as follows. So the most crucial issue before the Madhya Pradesh High Court was whether two Indian parties can have a seat of arbitration outside of India. And the court in this case actually upheld the observations of the Supreme Court of India in Atlas Exports and confirmed the fact that two Indian parties could choose a foreign seat of arbitration and that there was no prohibition with respect to two Indian parties choosing a foreign seat of arbitration. So it went on to hold that when parties decide to resolve their arbitration in a seat outside of India, Part 1 of the Arbitration Act, which relates to domestic arbitrations and arbitrations seated in India, would not apply. It went on to again very importantly hold that if the agreement satisfied the requirements of Part 2 of the Arbitration and Conciliation Act, Part 2 would apply, in which case the parties have to be referred to arbitration under Section 45. And therefore, ladies and gentlemen, the division bench of the Supreme Court dismissed the appeal. So here was a case, ladies and gentlemen, where the two-judge bench of the Madhya Pradesh High Court held that there was no prohibition on two parties choosing a foreign seat of arbitration. And if you see the line of decisions of various high courts, Sasan Power, this two-judge bench of the Supreme Court in Sasan Power, seems to be one of the most often quoted decisions in favor of the proposition that two Indian parties can have a seat of arbitration outside of India. And this, ladies and gentlemen, this division bench Supreme Court, Madhya Pradesh High Court decision went in appeal to the Supreme Court of India, and the Supreme Court of India, a two-judge bench of the Supreme Court of India, just give me a minute. Okay. A two-judge bench of the Supreme Court of India, ladies and gentlemen, held that this issue, whether two Indian parties could agree to a foreign seat or not, did not arise before it. It said that the issue before the Supreme Court of India, one of the three issues before the Supreme Court of India, was whether two Indian parties could contract out of Indian substantive law. So if you were to read paras 11 and 12, the Supreme Court very clearly says that this issue as to whether two Indian parties could agree to a foreign seat of arbitration or not was not a point which was brought in appeal before the Supreme Court of India. And the Supreme Court also clarified in this case that this issue as to whether two Indian companies can choose a foreign substantive law or have a seat of arbitration outside of India did not expressly arise because there was a foreign element in this case. Just like the Atlas Exports case, ladies and gentlemen, here was a case where there was a foreign element insofar as there were two contracts out here. The contract one was between Sasan Power and the North American Coal Corporation, the American subsidiary, the Delaware, registered company. And the second company was a novation between the North American Coal Corporation and its Indian subsidiary. So the Supreme Court held that this was not a simplistic case of two Indian parties agreeing to have a seat of arbitration outside of India, but there was a foreign element because of the involvement of the American parent of the Indian company. And therefore, ladies and gentlemen, this was again, in my view, was a case where the Supreme Court did not expressly decide this issue as to whether two Indian parties can have a seat of arbitration outside of India. And moving on from there, ladies and gentlemen, we come to this 2017 single judge bench of the Delhi High Court, Justice Mukta Gupta, who again, relying on Atlas Exports, held that two Indian parties could indeed seat their arbitration outside of India. And the last decision, ladies and gentlemen, in this line of cases on this issue, on this vexed issue, is a very recent decision of 2 months ago, 3rd of November 2020, Gujarat High Court, single judge of the Gujarat High Court, Justice Biren Vaishnav. And here, ladies and gentlemen, the Gujarat High Court, very interestingly, by quoting Atlas Exports and Sasan, upheld the freedom of two Indian parties to choose a foreign seat of arbitration. And it said that once two Indian parties make a choice of a foreign seat, it cannot be held to be contrary to the public policy of India. And the award from that arbitration seated outside of India between two Indian parties could be enforced in India as a foreign arbitral award. And again, it went on to very clearly hold that the applicability of Part 2 would be determined solely on what is the seat of arbitration, and the nationality of the parties did not play any role whatsoever in that question. But very interestingly, ladies and gentlemen, the Gujarat High Court in this case held that when two Indian parties chose a seat of arbitration outside of India, they would not be entitled to interim relief from an Indian courts in support of an arbitration under Section 9. So this again, ladies and gentlemen, I am not too convinced that this this ruling is correct because I don't think it has any substantive basis in any law or any precedent that just because two Indian parties have had a seat of arbitration outside of India, they could not be granted interim relief in India. I believe it goes squarely against what has been the explicit provisions of the 2000 of the 2000 of the Arbitration and Conciliation Act as amended by the 2015 amendments. So, ladies and gentlemen, I have given you a list of cases for the proposition and against the proposition with respect to whether two Indian parties can have a seat of arbitration outside of India. And my conclusion is this, that till date, there is no determinative decision by the Supreme Court on this issue as to whether two Indian parties can have a seat of arbitration outside of India. Secondly, the Arbitration and Conciliation Act of 1996, as amended by the 2015 and 2019 Amendments Act, is again silent on this issue as to whether two Indian parties can have a seat of arbitration outside India or not. So, ladies and gentlemen, given the fact that this matter has not been conclusively decided by the Supreme Court of India, my parting thoughts would be that one would have to tread with caution. And if you have to err at all, you might want to be erring on the side of caution and not on the side of daring. Because if you were to err on the side of daring, there would be a distinct possibility that the ground of public policy would raise its hood and your award could be challenged on this ground in an Indian court. So, on that note, ladies and gentlemen, I'd like to end my presentation, and I'd like to thank once again Vikas Chatrat and CLC for their kind invitation to give me this platform to express my views on what I believe is a very, very interesting aspect of the procedure relating to the Indian arbitration law and procedure. So on that, if there are any questions, I'd be very happy to take up questions now. I believe we have a very short time for questions, but very happy to take up questions, if any.
There's only one. Abhay Anand says, kindly share the citation of the GMR.
That's the citation.
Okay. So Abhay, you can note down that citation. Out here, we don't have any questions. I will just check it out on the Facebook. Yeah. So we are closing the screen sharing. Yeah. This is any suggestions to the students who would want or whom you want to suggest on arbitration?
I'm sorry, I didn't get you, Vikas.
Probably he wants to post the question as to what is the avenue under the Arbitration Act as a scope for a student to take this as a professional thereafter.
No, I think arbitration is a fantastic profession, and given the recent evolution of the jurisprudence relating to arbitration, given the recent support that the process of arbitration has got from the government, given the recent amendments to the Arbitration and Conciliation Act, and the moves of the government to establish India as an arbitration hub, I believe the future of arbitration, the study of arbitration, is very bright. And so those of you students in the audience who want to make a career in arbitration, please do so. But I would suggest do not directly specialize in arbitration right from day one. It would be very important for you in the first few years of your career to be a general dispute resolution lawyer, having an exposure to both the court system as well as arbitrations. And then a few years down the line, take that conscious decision to specialize only in arbitrations. Because we must remember, as I said at the very beginning of the lecture, arbitration doesn't function in a legal vacuum. At every point in time, you will need the assistance of the courts, and therefore arbitration would have that interface with the court system. And therefore, it is very important for young students and lawyers to understand how that court system functions. Hence, my suggestion that please do not specialize in arbitration right from the word go, but try to spend the first few years by being a general dispute resolution lawyer, including doing trial work in the trial courts. Actually, very, very important to hone your skills of cross-examination, which I think plays a very, very important role as a good arbitration lawyer.
There are two questions that popped up from Pavni.
Yes.
Essentially, isn't that the procedure for enforcement of domestic award different from the international award? If so, if two Indian parties go for international arbitration, then the award will be deemed to be an international award and enforced in accordance with the New York Convention. What is your take?
No, that is exactly what these decisions seem to be saying, that when two Indian parties have seated the arbitrations outside of India, part 1 will not apply, part 2 will apply, and all the decisions which are quoted, the Gujarat High Court decision and the Delhi High Court decision, and also Atlas Exports, say that the moment you have made a choice of a seat of arbitration outside of India, what really matters is not the nationality of the parties, but what matters is the seat of arbitration. And once you've agreed to a seat of arbitration outside of India, part 2 of the Arbitration Act and not part 1 will apply. And once part 2 applies, then it would be considered to be a foreign award for the purposes of enforcement.
Ajay, we don't have any other questions. I've just checked it at the YouTube as well as on the Facebook.
Okay.
And
so, which is I think a good sign that the fact that everybody has understood this concept is crystal clear.
Yeah. You always take the sessions which are very painstaking. So tomorrow, friends, the topic would be interpreting the Constitution, the evolution of an Indian method by Mr. Sirinidhi KR, who is a professor in CMRU School of Law, Legal Studies in Bangalore. So do stay connected with us. And thank you to all those participants who have been watching us live on the Facebook, YouTube, and on this platform. And above all, to Mr. Ajay Thomas, who as usual gave the session in a very articulated manner. And as he rightly said, since the questions have not come, a lot of people would have understood the concept and the gray areas which he wanted to show, and certain doubts which would have been there with the participants. I think they would have been dispelled with. Thank you, Ajay, and thank you to all the participants. Thank you. Everyone stay safe, stay blessed.